And we have now Assemblymember Jones Sawyer, who has been waiting patiently. And he and his staff are in matching orange. This is very impressive. All right, this is file item 13, members, AB 610. AB 610, good afternoon, sir.
Thank you, Madam Chair and committee members, and thank you for hearing my bill today. I also want to thank the committee consultant for a thorough analysis. Nobody wants to appear soft on crime. However, AB 610 is a pragmatic solution for alleviating recidivism as well as preserving the fiscal integrity of the state. One of the biggest impediments to successfully reenter into society is debt, specifically child support debt, accrued by parents during their time of incarceration. Consequently, parents who were formerly incarcerated are released from prison with mountains of accrued child support debt. A large portion of this debt will likely never be repaid back, as many ex-offenders are of lower socioeconomic status, which hurts them, hurts their families, and the state of California. This pronounced indebtedness not only feeds recidivism, but puts an additional strain on both parent-child and parent-parent relationships. In 2010, this legislature passed a law to allow for the freezing of child support orders for incarcerated parents if they had no income. The original intent of the law was for incarcerated parents to request this option through the court system or administratively through the Department of Child Support Services. AB 610 extends this existing law to permit a parent who is incarcerated with no income to freeze their child support order only if both, I repeat, both parents have no reservations. The child support agency must alert the custodial parent before making any administrative modifications and manage the subsequent court case if there is a concern. This bill will also hold DCSS accountable by tasking them to assess the effectiveness of the administrative adjustment process and report back to this legislature. AB 610 will help curtail the problem of uncollectible and unmanageable debt held by formerly incarcerated parents, which inevitably makes reentry even more challenging. Moreover, extension of current law through this bill will also help reduce financial and penalties imposed on California by the federal government for our state's accumulation of uncollected child support debt. Here today to testify is Karen Lang, legislative advocate for Placer, San Joaquin, and Stanislaus counties, and Tammy Olner, Placer County Deputy Director of Child Support. Thank you, and I humbly ask for your aye vote.
Thank you very much. Can we get the mic up there, please? Is it up? Try it again. No, that isn't working. All right. We don't have either mic working. Is it working? Try it again.
Okay, I can talk. Oh, there it goes.
My bad. Okay.
Sorry, not the first room where people try to shut me up. So
no. Happy to hear your presentation.
Thank you very much, Madam Chair and members. Karen Lang, on behalf of the Placer and Butte County Boards of Supervisors. Why the boards of supervisors care is because their departments have to administer this law, and their departments are telling them that the law didn't work in its current version. It did sunset on July 1st, 2015. Mr. Jones Sawyer was willing to take the bill on for us, but he was willing to also make some amendments to the law so that it worked better for county departments and they could make those adjustments administratively instead of having to go through the courts, which sometimes could take up to 3 months. And anecdotally, they found that folks that had been in the criminal justice system weren't overly eager to get back into a courtroom, which is why in the several years that the bill had been the law, it had only been used about 100 times successfully, which sort of boggles the mind. So we're hoping that the revised version that Mr. Jones Sawyer is carrying today will result in better usage of the law and hopefully ultimately better connections when folks leave prison and they can reconnect with their families without huge arrears that accrue at 10% interest and pretty much can never be wiped away. So Ms. Euler is here today to answer any technical questions. As you know, child support directors are not allowed to advocate directly to the legislature. She's here purely for technical assistance. And for all those reasons, ask her I vote today. Thank you.
Thank you very much. So you're here for technical assistance, can't advocate, but let's go ahead and have those who would like to speak on behalf of the bill. If your name, affiliation, you could take 30 seconds if you would like.
Madam Chair, members, Karen Keene on behalf of the California State Association of Counties in strong support.
Thank you.
Katia Belsky with Legal Services for Prisoners with Children, and we just want to say that released parents already face such an unimaginable burden. Adding the accrued debts and the interest that the Assemblymember talked about is just unimaginable, and we're in strong support of this bill.
Thank you. Other witnesses in support?
Hi, my name is Tahari Kademi, and on behalf of all of us who are none, we are in great support of this bill.
Thank you. Other witnesses in support? Are there any witnesses in opposition? All right. You know, I appreciate this. I sadly practiced in this area for many years, and what's so frustrating to me is that when someone is incarcerated, the burden to care for the children, in addition to other burdens, falls 100% on the parent who is not incarcerated, and thus the children suffer. And so it's very, very hard, I think, conceptually, to say to someone who is incarcerated, hopefully for bad, I mean, hopefully that the system worked and they are properly incarcerated, is absolved of the responsibility for caring for his or her children. So I have a philosophical problem with this issue. But as you say, this is a practical solution. It is my hope that, and I don't know if anyone will be keeping records, but I hope that they will, so that at the end of the period of time, we can see whether this is in fact resulting in parents, once they are released from custody, once they are back potentially in the workforce, are supporting their children. Because it is the children who suffer under these circumstances. So I appreciate, and I know there is no perfect answer. I know that there are amendments in the analysis that you are taking as authors' amendments. So this bill, I guess, is as good as we can get in a very difficult circumstance. And there's just a no-win here, but appreciate, and I would like to see that at the end of the day, this is inspiring parents who have been incarcerated to start supporting their children at the first available moment. That's who this is all about. So we have a motion.
I move the bill.
By Senator Wojtkowski, and I assume you would like to just ask for an aye vote?
Yes, I respectfully ask for an aye vote.
Very good, thank you. Do pass as amended to Senate Appropriations. Please call the roll.
Jackson.
Aye.
Jackson, aye. Morlock.
Aye.
Morlock, aye. Anderson. Hertzberg.
Aye.
Hertzberg, aye. Leno. Monning. Wojtkowski. Wojtkowski, aye.
4-0. Thank you. We'll put that on call.
Thank you very much. Thank you.
All right, file item 15 is up next. Assemblymember Calderon, I didn't see you back there. Perfect timing. File item, the Assemblymember has file item 15 and 18, and we will do those next. File item 15, AB 691. Good afternoon. Almost good evening.
Thank you, Madam Chair. I'll go ahead and get started as my witnesses join me up here. Good afternoon, Madam Chair and members. As Californians increasingly use and store information on services like YouTube, Twitter, Facebook, and email, it is important for us to consider what happens to all of that private information collected on online accounts even after the owner of those accounts passes away. The digital era has brought us a new and fascinating way to reach out to our friends, share intimate moments with family, and adds a new layer of complexity to the human reaction of dealing with death. A recent poll found that 70% of Americans say their online communications and photos should remain private after they die, unless they gave prior consent for others to have access. 65% of Americans say it is a violation of their privacy if their information is shared without such consent. This is a clear and present need to address this issue and to address it now. On too many occasions, families have gone to court trying to access information in order to administer the estate of their loved one. However, the standard practice of providers up to this point is to block access unless there is a court order, because federal law only allows disclosure if only one of the parties of communication consents. AB 691 addresses this issue by striking a balance between providing a clear path for fiduciaries to access relevant information to handle the deceased person's estate, while also respecting the privacy choices of the deceased person and those with whom the deceased was communicating. Specifically, AB 691 establishes a guideline so that probate courts, online service providers, and estate administrators know what information is needed to provide access to copies of records or content of the online information necessary to administer the estate of the decedent. We have seen different approaches around the country that attempt to grant default disclosure to administrators instead of protecting the wishes of the deceased. Several privacy groups such as the ACLU and Electronic Frontier Foundation have been opposed to this approach. California must be a leader in protecting the privacy rights of our citizens. We have an opportunity with AB 691 to establish model legislation for other states to look to for guidance. This bill is supported by the Internet Association, Mental Health America of California, State Privacy and Security Coalition, Civil Justice Association of California, the California Chamber of Commerce, Yahoo, AOL, Facebook, TechNet, and many, many others. Further, AB 691 was extensively amended in the Assembly to address concerns raised by the State Bar and Judicial Council, and we will continue to listen to any future concerns raised in order to address any outstanding issues. This bill has bipartisan support and has yet to receive a single no vote and pass off the Assembly floor 79-0 and has no formal opposition. Thank you, and I respectfully request an aye vote. With me today, I have Ivan Altamura with Yahoo, John Doherty with TechNet, and Robert Callahan from the Internet Association.
Move the bill.
Thank you. Witnesses, please.
Good evening, Madam Chair and committee members. I want to start by thanking the author and the chairwoman and your staff for extensive work and discussions around this issue. My name is John Doherty on behalf of TechNet. We are pleased to be before you today as co-sponsors with the Internet Association of AB 691. I think with this bill, it's important to start with what the bill is versus what the bill is not. AB 691 was drafted to address a specific concern created by an intersection of privacy rights, federal law, and the probate process. The Federal Electronic Communications Privacy Act does not allow for disclosure of the contents of an electronic communication, for example, email, posting, blogs, without the consent of the user or the recipient. And that consent has to be actual consent under Negro versus Superior Court, which found that before this information can be released, you can't impute or imply consent. It has to be actual consent. It should also be noted that since almost all email traffic involves more than one person, third-party privacy rights are in play during the debate. Within these restrictions and concerns, AB 691 sets up clear guidance for how to obtain non-content information within the probate context and guidance to obtain content if consent can be shown. What it is not is that it does not require a probate proceeding to obtain the information, nor does it impact other avenues for discovery via subpoena or other legal means for this information. Finally, it does not attempt to address every issue that could come up with electronic assets or communications within a probate court proceeding. As the home state of many of the world's leading technology companies, we urge this committee to take the lead on this narrow but significant issue and support AB 691. Thank you.
Good afternoon, Madam Chair, members. My name is Ivan Altamura. I'm with Capital Advocacy, and I'm here on behalf of Yahoo. We're in support of the bill, and we believe that this is a good balance between protecting privacy and also providing a tool for estate administrators when they are in probate and they are trying to locate assets of a decedent. When someone passes away, the more tools that an estate administrator has to locate assets, the better off they are to make sure that that person's estate is properly administered and the heirs get what's rightfully theirs. We believe that this bill provides a necessary pathway and an additional tool to what administrators already have to help discover assets that should be drawn into probate if it's otherwise not known to the executor or the heirs of the estate. We think that this bill allows providers to give information that can assist in the administration of an estate while at the same time protecting the privacy of the communications of the decedent as well as the third-party individuals who receive those communications. So for these reasons and for all of the reasons stated by the author and my colleague, Yahoo is very supportive of this bill and requests that you support it as well.
Thank you. Other witnesses in support, just name and affiliation, please.
Yeah, Robert Callahan with the Internet Association here in strong support. Thank you.
Thank you. Other witnesses, please.
Michael Bolden on behalf of the Service Employees International Union in support.
Thank you. Other witnesses, please support, just name and affiliation, please.
Jeremy Mers on behalf of the California Chamber of Commerce, also in support.
Thank you.
Madam Chair, committee members, Pat Zenzala with KP Public Affairs. I'm here on behalf of Google in support of the bill.
Thank you.
Madam Chair, committee members, Ann Blackwood on behalf of Facebook in support of the bill.
Thank you.
Thank you, Madam Chair. Cliff Berg on behalf of AOL in support of the bill.
Thank you very much. Other witnesses in support? Witnesses in opposition?
Samantha Corbin on behalf of Electronic Frontier Foundation. Right now we're neutral on the bill. We do have some small concerns about implementation, but are talking with the author's office and others about that, but again, remain neutral at this time.
All righty. Anyone else in strong neutrality?
Very strong.
All right. All right. We've been talking, and I have some questions, and I appreciate the effort. This has been a very robust discussion because privacy is really just a fundamental right, and I think we all share a real commitment to this. But as you know, one of my concerns has been how do we implement these protections at the same time allow executors and administrators to execute estates once a party dies. And we've discussed this. I'm not sure we reached a resolution. It's my understanding the right of privacy does not survive somebody's death.
That's right.
So what we're doing here is we're saying that we are going to let someone's privacy survive their death because it's going to require either that somebody agree in advance through settings or what have you that they are either going to give permission to someone else to access their email or not give permission, or if they're silent, then they haven't given permission. So that's the way this is starting. I wouldn't know this because I have to have my daughter figure out my settings. I don't know what they mean. I just know that I want to get my email, and I will assume that I'm among the dumb part. Most people know better, but there's still enough of us dummies that we don't. Particularly old people who should be concerned about their estate planning. That being said, if I am the executor of someone's estate and I want to find out where they bank and whether or not they're engaged in any transactions or they have any debts, because one of the things that you are required to do as an executor is ascertain assets and liabilities. And if somebody actually keeps most of their records online so that you don't go to someone's study or closet and find all their materials, you know, with their bank accounts and so forth, where are you going to find them? So if I am an executor to an estate, unless I have that person's access information on their computer, I'm not going to be able to get it. The only way I can get it is if I file for letters of administration. And I have to be an executor, you know, and I've been designated. Let's say I've been designated. So I have to go into court to just get those preliminary letters in order, and we talked about it in terms of the envelope and then the content. So if you think of the computer, or the email list, you can go down and find out the name of someone to whom an email was sent, the date, and the subject matter, you know, account. That's the envelope. And in order to do that, as I understand it with this bill, you have got to go in and request from the court the ability to just simply get the envelope. And requiring a court action just to be able to get into the internet account of the decedent. If you want more than that, let's see, if you want to get more than just the envelope, you have to then go back to court and show good cause why you should be able to go in and get that person's, the actual content of the email. Is that correct?
I don't think I think that's pretty close to how I would describe it. I think that there would be 2 points I would make at the outset. One, and I said this in my opening, both D and E, subdivision D and E in the bill were put in there to make clear that getting a court order and all of those letters is not the only way to get this information. So there's a permissive subsection in D and E which say, look, if you provide this to if you give this information to the provider, they're allowed to give you both the outside of the envelope with D1 through 3, if you give them that information, and content if you can show consent through the will or trust of the deceased user. So there's actually multiple ways to do it. The other thing that I would quickly say is that it's not good cause, really. The bill does say if you are in court, you have one set of relatively simple facts to prove up to get the outside the envelope information, and you have an additional very important fact that somehow through admissible evidence you show consent. And the reason that is so fundamentally important to us is, despite the fact that under common law your privacy rights do tend to, not completely, but do tend to certainly dissipate or disappear upon your death, statutory rights, especially the statutory rights created under ECPA, prohibiting unauthorized disclosure, do not disappear when somebody dies. And ECPA is enforceable by not just the sender, but the recipient or the alternative party. So there are lives in being for us law students and lawyers that are out there that could sue for unauthorized disclosure, regardless of whether or not your right to privacy has expired.
All right, I have some other questions, but Senator Hertzberg, if you wanted to go ahead.
I just want to just take a moment to examine the point you raised, because I didn't think about it until you just raised it. But look, in society, as technology changes, we see all sorts of differing approaches in rights. I mean, for example, I would suspect a modern lawyer today in the will, in their check form, when they do a will, would ask, do you want your executor to have this information? And they asked that question. I just went through and did my estate plan. They asked me the exact same question. At some point, what if I took all my bank statements and I threw them away, right? And you're an executor. You don't have access to my records. You'd have to go to the underlying bank to get my bank records. So the question becomes, in terms of our behavior as a society, what do we do with all sorts of new technologies that otherwise exist? They just disappear because we know now that everything we ever do on our phone, or every text message we ever send, or every email we ever send is somewhere in the cloud somewhere, right? And so we're going to have this massive amount of information. And what do? It seems to me that you should put that in part of your plan at some point, to some extent, and/or companies will start, in order not to carry all this information, because obviously I suspect since the internet started and since these various technologies started, there's been a lot of data that's held on, and there's certainly been human beings that have passed away that have put that data. So I would suspect that what you're going to see is companies, just like on their forms, are going to ask you that kind of stuff, because they're not going to want to keep it forever. And to make that determination. And there's also going to be, at some point, this last point, some connectivity between the death records and so that these companies can otherwise be informed. Otherwise, the massive amounts of material just keeps growing and growing and growing. Or there's a lot of stuff that may not be relevant to anything that no one ever else wants. So all I would suggest is that, just like what we're seeing now in market conditions, you're going to start to see those kinds of things change when people sign up for an email account or whatever the case may be. I don't know how we protect it for the probate thing. I just don't know how we get there.
Well, that's been part of the discussion. This is an interesting issue. It isn't just a question of privacy. We're trying to balance what happens when a person dies and the estate has to be sort of unwound, and debts paid, and assets identified, and distributions made to beneficiaries. Not everybody has a will. or a will that's up to date with all these considerations. So I guess part of my question is that what this bill does, as I understand it, it requires the executor to seek court authorization before they can send out a subpoena for the production of documents. We don't have that in a normal probate proceeding. We say to the executor, you've got responsibilities, you're going to have to come back and account to the court, but you go out and do what you need to do. In fact, we put a 4-month time limit on them. You can't get into court in 4 months to get anything these days. So that presents a problem. I mean, I'm not trying to be difficult about this, but we have been asked to try to address this issue of what happens after somebody dies. This then puts an onus on the executor to try to figure out, even if you can get the outside of the envelope, what it is that you need on the inside. And if you don't have consent, if it's just not that clear, how are you as the executor going to get that information? From what I hear in the bill, you don't get the information. You're out of luck.
And Madam Chair, just to clarify for the members, what we're asking for in the bill is that either on the settings of the profile, if it's a social media site, that you do indicate that, yes, you want your information shared in the event of your passing, or no, you do not want your information shared in the event of your passing. And the other alternative is in a written or oral will, meaning you take your phone and you talk into the notes portion of your phone and say, in the event that I die, I want my information to be shared with my executor.
Yeah, and every 30-something's going to do that in their phone.
Or it could be written, and that could be done by a lawyer in written form. But our argument is that this will make the process easier and simpler, especially in the cases that there is that consent, because these companies otherwise are going to assume that they, under federal law, do not have to give up that information, and it is going to be a court order in which they get, which is standard law now, to get that information. And so we would argue that this would help make it easier, and we are dealing with a new time. And so given the new technology that we are experiencing today, that is continually, which the chair made this point, outpacing us, especially as lawmakers, to control, is that should the gold standard continue to be that we no longer have privacy after we pass away when you're dealing with online communication and the amount of information that you have, and especially when 70% of Americans today believe that they should have privacy.
So this is a conversation, fascinating, and you know, the number of angels dancing on the head of a pin is something all lawyers love to talk about. I have to say I'm very disappointed that we didn't have the bar, or is it the probate section of the bar here to just at least help with this discussion. I don't think it's particularly fair that we're asking the industry or the Assembly or the Senate to try to work this out without sort of some of the key stakeholders involved, but they have chosen, for reasons that are disappointing, and I don't know quite what they are, not to participate in this debate. I'm going to tell you, I'm going to stay off the bill today because I just, there are too many unanswered questions for me, but I have no recommendation to others. I just would really like to continue the conversation at some point. I just don't feel as though I've really got my arms around all the concerns that are expressed in spite of the best of faith efforts that the authors made with all of you here. So, Senator Wojtkowski, if you wanted to raise
I appreciate the author and everybody in computer and internet land coming and visiting me on this bill. Unlike my colleague from Los Angeles, it's not the data that I want. It's the asset. It's the liability. If in the old paper days, I walk in with my letters. I go to probate. I'm the personal representative. I've got the will. It says I'm the personal representative. I've got the letters. I get the assets. It's not a discussion. We don't get to say, well, does the will say that you have expressed consent for disclosure of the bank account or the safety deposit box? They give me the key, I get in. There's no talking. So that's the question I'm trying to drill down between, you know, I agree with the observations. Your privacy dies when it doesn't exist when you die. I get the fact that there's a federal law, but with regard to just the assets, you know, or the debt, everything's on your phone. The author, everything's on your phone. I need to find out who who your debts are. I don't care about the backup information on the computer. What's the bottom line? $24 to AT&T or whatever it is. That's a concern that I have right now when you say, if the letters are not enough and I need express consent, best practices for the attorneys is great. Somebody who wrote a will 15 years ago thinks it's perfectly good. We got different results here. So I guess that's the question is, when you say deceased users express consent for disclosure of the contents.
So I'm happy to, I'm happy to address that. So the bill has, I mean, I don't want to say absolutely nothing to do, but the bill is not about assets, right? I mean, you're right. You have a right to get at the asset just like you always have. The issue is the data. So the emails you've sent back and forth to people, everybody, your bank, your wife, your kids, all of that stuff. What the concern is that federal law very strictly prohibits the release of that by an electronic services provider without consent. We are trying to provide the clearest way forward for somebody to figure out, am I missing some assets here, right? So, Grandpa has a Bank of America account, but does he or she or grandma have a Visa or a Wells Fargo account? Well, that outside the envelope information can help you track that down, and then you go to that bank and you say, I'm the executor, does Grandpa have an account here? And if you do, you get it. What you don't get is the communications, I've had and the content of those communications. So fundamentally, you're right. The probate proceedings is not about diving through content. It's about finding assets. I think the chairwoman's concern is how do you make sure you find those assets?
You miss them.
If you miss them. Well, I mean that is the tension that ECPA and privacy rights create between but we are. The current system without the bill is not working because it's ending up in disputes because people are asking for all this information. We're having to deny it because there's no proffered consent. This would actually make it clear. The other thing I would say is that we have committed with the State Bar to form either a formal or informal working group to create a form so that it does help people moving forward. I understand your point that a 20-year-old will might not have that, but it doesn't change the fact that you can't unwind the statutory privacy protections or the privacy concerns of the third parties that you're enabling in a different way than we're doing this. So, I
think that people, when I'm named as a personal representative, they don't say, unless you do online banking, then you don't get access to that. You say, or unless I communicate online or through, Yahoo service or whoever it is. I mean, I'm going to move the bill because it may have not taken as clear a step as I feel comfortable with, but I realize that it may be helpful. I think we have to do, all of us need to do more work in this arena because, my understanding is when the judge orders me to be, accepts me as the executor, that's an order of the court. I'm recognizing you, and I'm empowering you with everything that's on the probate code. And maybe the probate court needs to say, and you have the express consent to obtain information from internet providers or whatever it is. I don't know what it is, but I'll move the bill.
And I might say that, as I understand it, the federal courts now are making orders requiring some of the companies to hand over information after death. So I don't think this is settled law anywhere. And I think that it really is something we've got to address and tackle more comprehensively, because that obviously it puts you in a bind. But as policymakers, I think we have to decide whether or not we want to change the whole notion that the right of privacy dies with you. And I think the federal courts are sort of taking a very mixed approach to it. We probably, at some point, need to give some guidance whether we want to extend that. As you say, about 70% of the public wants that right to continue after death. But is that good public policy? And we're not addressing that here. And I think that's a very important part of this discussion, because it will, I think, sort of weigh how, in what direction we move with some of this legislation. So with that, if you'd like to close, and we have a motion, so we'll go ahead and vote at that point.
Yeah, Madam Chair, Senators, I really appreciate the discussion, because it is an important discussion. I mean, it's a step. It's a small step in dealing with the extremely complicating issue, but an issue no less that isn't just now at our doorstep. It has been at our doorstep, and current law does not provide sufficient enough of an answer to deal with it. We're trying to provide executors, individuals, the ability to settle their assets while at the same time protecting their privacy even after they pass away. That is the point of the bill. We think it makes that process easier, provides some type of guidance for the executor, for the lawyers, for the court. And so with that, I respectfully request an aye vote on this measure. And we will continue to work with everyone, including the chair and the senators and the tweeners.
The tweeners, sorry. Thank you very much. Madam Secretary, the motion is due pass to the Senate floor.
Jackson.
Not voting.
Morlock. Aye. Morlock, aye. Anderson. Hertzberg. Aye. Hertzberg, aye. Leno. Monning. Wachowski. Wachowski, aye.
3-0, the bill's on call.